Hi, I'm Elizabeth Talbot, and I'm with the Talbot Law Group in Walnut Creek, California, and I'm the estate plan coordinator and paralegal. And today I'm going to talk about probates and bonds for administrators within a probate. So whenever you have to go through a probate, and generally a probate is done if you have over $150,000 and there's no trust, there can be a will and you would still have to go through probate. So whenever you have to go through a probate, generally, unless there's a will that waives bond, the administrator is going to have to be bonded. Now, what does that mean? It means that the administrator of the estate, called in a will the executor, but overall the overarching term is administrator, will have to have a bond to insure them, essentially, against stealing all the assets. Worst case scenario, they take all the assets, they go to a different country, and this bond would ostensibly pay the beneficiaries for the assets that have been taken. In most cases, of course, that's completely not relevant. The administrator in no way does steal the assets, but the bond is still necessary. So there's several conditions under which a bond may not be necessary. So one of those conditions would be, as I stated, if there's a will and it waives bond. However, the beneficiaries can also sign bond waivers and file them with the court. So if all the beneficiaries of an estate signed waivers of bond and filed them with the court, the administrator may not have to have a bond. Now, one question that comes up on a rather frequent basis for us is when we have administrators that are out of state. Out of state administrators often do have to be bonded regardless of whether or not the heirs waive bond. So even if the beneficiaries file a bond waiver, the court will often require those out of state administrators to be bonded. And sometimes, though, if you have an administrator out of state and a bond waiver is signed by the beneficiaries or heirs, the court will reduce the bond. Because the greater the bond, the more the estate has to pay for that bond. Now, let's talk about what happens if the administrator cannot take out a bond. That means that they are not bondable. They do not have the credit to take out a bond. So in that case, what the court has to do is they put all the money in a blocked account. So it's a special type of bank account where you put all the money and you can only get it out with a court order. So this happens from time to time in our probates and essentially and also conservatorships. So essentially the money, any money for the estate, for example, if a house sells or any other assets sell, or the decedent, the person who died, had significant bank funds, those funds will be moved into an estate account that is blocked and cannot be accessed without court order. So that means that any time that administrator needs to get funds out of that blocked account, they will have to get an order from the court. Now, of course, there's some necessary costs of administration along the way. Often the court will allow the administrator to keep enough funds on hand to pay some of those costs. So that's the basic situation with the bond in a probate. Generally, when you're working with an attorney, they'll also have a bond agent they can refer you to, and that person can help you with getting a bond and also checking whether or not the person is bondable. One thing to keep in mind that we typically do is if the beneficiaries are willing to waive bond, we will always ask the court to attempt to waive the bond. So for example, if there's an out-of-state administrator and we know the court's going to require a bond, we'll still ask them, hey, this beneficiary waived the bond and this other beneficiary also waived the bond. Would you consider either no bond or reducing the bond? And in some cases, they will do that. Thank you very much.